vote can be ignored once it's given. It's a tough question.
Okay, so Judge Hopkins, we move to you again, and 546E is a mess. The circuits are all over the place with respect to the defense to fraudulent transfer actions and other avoidance actions. The 11th Circuit, my circuit, I think a long, long time ago, kind of got it right, but Judge Hopkins, what's happened since then?
I think the 11th did get it right, and if you apply their rule, it makes it fairly simple. For those of you who are sort of new, 546 is an attempt to curb the trustee's ability to avoid a fraudulent transfer that occurred that involves a stock transfer. There's one exception that the trustee can bring the action, and that is if it's a fraudulent transfer under the actual intent to defraud, provisions of 548. So constructive fraudulent transfers are out, and the trustee is barred from bringing it. In a situation where you're dealing with a stock trade that involves a financial institution and participants in that stock trade. Essentially what the rule says, it's a safe harbor. You simply can't bring that action as a debtor or the estate on behalf of creditors. You're barred. The 11th Circuit in the Mumford case back in the 1990s, I believe, created an exception to that. They said essentially if you're a conduit bank, and you're just a conduit, you're a financial institution, but you're not benefiting from it, which is part of the language of the statute, then you can go after that transfer and avoid the transfer and bring back the payments that went to the old equity and for the value, to enhance the value of the estate, to promote the idea of an equitable distribution and all those good things that bankruptcy stands for. Now, since the Mumford case, there have been some more recent cases from the 3rd and the 2nd Circuit, significant circuits, obviously, when it comes to cases of this sort. The important part to acknowledge about this is that the impact of the safe harbor provisions of 546 will be on mid-sized cases as well as on major cases that affect the market. And if you look at the legislative history of 546, this rule was intended to protect the markets from collapsing. That's clearly not the way the circuits have applied it. They've applied it to private transfers between individuals in a single or a two-party stock trade. The 3rd Circuit came out with the Resorts Inn case in 1990, essentially using a claim meeting analysis under 546 and denying a trustee's claim seeking to avoid payments in a shareholder leveraged buyout situation, expressly rejecting the Mumford decision. And then it was followed more recently by the 2nd Circuit in the Enron recovery case. The Enron case essentially follows the 3rd Circuit and expands the rule to hold that redemption payments, whereas settlement payments in a stock transfer are entitled to protections of the safe harbor provisions under 546E. Judge Drain and Judge Gerber's court had a decision involving a private stock transfer that was decided only months before the Enron case came out, and in a subsequent decision by Judge Peck from Bob's court, he essentially said he believes that that case is sub silentio overruled now by the Enron case, which applies across the board to both private stock transfers involving a settlement payment and public transfers.
You know, Jeff, I think Jim Peck may have been right on that, but the bottom line of that is, for all of you guys who thought that creditors are supposed to get paid ahead of stockholders, well, that doesn't apply anymore. You can, the shareholders can be paid ahead of the creditors, and there's very little that we courts can now do with it.
Right. I think it really turns the equitable distribution doctrine that we all learned to bankruptcy on its head, because now equity is going to enjoy the safe harbor under these holdings by the 3rd and 2nd Circuit, and they're joined. There are other circuits out there. My own circuit, the 6th Circuit, is in alignment with these decisions as well as the 10th. Mumford stands alone as the only circuit that seems to mollify the principle that the safe harbor seems to promote. Good question. There are a couple of cases to watch, and be careful because Judge Gerber has one of these cases, because lawyers are coming up, the creative bodies that you are, with some very creative theories to try and circumvent the impact of both Enron and the Third Circuit holding regarding the safe harbor provisions. The one is the Lyondell case out of the Southern District of New York, where several entities filed after a leveraged buyout overburdened the debtor with debt. And so the creditors committee, acting on behalf of the estate, has filed a lawsuit in that case to avoid the transfer under, I think it was constructive fraudulent transfer action, and also joining 544B claims under New York state law. Well, they settled with one of the lenders for a substantial sum of money, $450 million. But then the committee, by specific provisions in the plan, correct me if I'm wrong, Bob, I think the committee, the debtor expressly abandons any claims that it has with respect to constructive fraudulent transfers that occurred, and says it's not going to pursue those. It also creates a creditor trust, and the creditor trust, after the plans were confirmed, went into state court and filed fraudulent transfer actions against some of the shareholders, seeking to avoid those transfers and bring back those funds into the estate, or at least into to recover for those creditors. That case was removed. It went to the district court. It went from the district court, and now it's back before Judge Gerber for adjudication. Of course, as one would expect, Old Equity filed a motion to dismiss, citing provisions of 546E, the safe harbor provisions, saying that you're barred from bringing this action, and it's an impermissible thing to do. But then you've got the shareholders, or the creditors on the other side, or the trust on the other side, arguing that the bankruptcy filing doesn't extinguish the claims. The claims still exist, and they still belong to the creditor body, and they're referred back to the creditor body upon the confirmation of the case and consummation of the case, and that this trust can now pursue these claims. And so I think Judge Gerber has a work cut out for him to sort of decide what happens with that. But it's, again, it's a very creative lawyering on the part of those counsels representing those creditors in that instance. Tribune Company is the other case in the Third Circuit, which is a little bit different from the Lyondell case. There you had a leveraged buyout which settled the Tribune companies. There are about 170 of them that are filed a joint case in Delaware. They are settled with over $10 billion worth of debt. There you had the committee on behalf of the estate again seeking to avoid the constructive fraudulent transfer under the actual, they filed a claim, this is important here, using 548A1, which is the actual intent to defraud, and using the state law. They didn't assert constructive fraud in the case that was brought by the committee in Tribune, and left that for another day. The note holders then went into, filed a motion in the bankruptcy court seeking a determination that the cause of action for constructive fraudulent transfer reverted back to them, and they were able to pursue it. And they also sought relief from stay. So these are the actual creditors and note holders themselves using the fraudulent transfer law, trying to have the court determine that they could bring these claims, not the estate. And they use a very clever argument saying that 546E says that the trustee is barred from bringing these kinds of claims, but not the note holders, not the creditors themselves, and they revert back once the estate has abandoned them, and they should be given relief from stay to be able to pursue them. Now, interestingly enough, the creditor, the shareholder, Old Equity, was arguing obviously the opposite of that and trying to prevent They said it was an in-run about around 546A. They cited the Heckinger case, I believe, out of the Delaware court, saying that this is an attempt to use an estate claim in a fashion that's impermissible. That case is yet to be decided. They were trying to run out the clock, though, because under 548, you've got a 2-year window in which you can bring the claim. So what they did was essentially ask the judge in the Delaware court for the ability to file their claims in district court so as to preserve those claims and not have the statute of limitations run. And they were successful. The court granted that relief, but then further stayed that litigation. So there are about 50 claims now that are lawsuits that are pending in before a multi-state panel of judges awaiting the automatic stay in the Tribune case to be lifted. So it is a state of confusion somewhat, but again, it's a bit of creative lawyering to try and run perhaps the 546E bar.
Judge, are you seeing any other kinds of creative lawyering in connection with clawback claims or standing or issues like that?
Well, I'd say just about every variant of that. An area where the action is, and I don't want to comment on substantively, picking up on something Jeff said, is since a lot of these claims have their origin in state law, people bring suit in state court or rely on their state law rights where there isn't a 546E. And those issues will play out in time. I'm seeing arguments, I can identify the argument, I'm not going to predict a ruling, that say that state law fraudulent conveyance claims are preempted by 546A. But other than identifying the issue, I'm not going to speak to it.
Okay, let's move on, Judge Gerber, while you have the microphone. You're going to tell us about some issues that arise with respect to director and officer liability in closely held entities.
Yes, Trish. Picking up on something that Jeff said a moment ago, you certainly don't need me to tell you this, is that in a lot of our 11s, Chapter 11 cases, both the largest and the mid-market ones, we set up, or the creditors set up, litigation trusts on behalf of the creditors to bring in recoveries on claims that will provide additional funds to pay creditor claims. And very often in that kind of situation, they involve claims of breach of fiduciary duty by the officers and directors. Sometimes, less commonly, also aiding and abetting the breaches of fiduciary duty, but I'm going to really be talking about claims against the officers and directors themselves here. They involve an amalgam of issues that we've been dealing with for years, and principles that we've been dealing with for years, and some new thinking on some of them, and I just want to talk about 2 or 3 in the new thinking area in that connection. In mid-market cases, by the way, we also have a lot of closed corporations, corporations with only one shareholder, just a few shareholders, which are obviously very differently run than public companies. And issues that we're wrestling with are the extent to which the rules that apply to large companies also apply to closely held corporations when the officers and directors may think that they're only gambling with their own money. So let's talk about that for a minute. This summer I issued a decision in a case called Fox versus Koplik, in Ray Perry, Koplik and Sons, which involved a combination of a corporation that had only family shareholders on the one hand, but millions of dollars of creditor claims on the other. And as you can imagine from the fact that it was before me, the company went belly up, leaving creditors with millions of dollars of unsatisfied claims, and claims were brought against the officers of the company and the directors of the company, which also happened to be the same officers. And then we had to deal with 3 issues that you're very possibly going to deal with in your own mid-market cases. and they involve whether fiduciary duties change depending on whether the debtor is insolvent or not. And what happens if, by way of example, the officers think that their company is solvent, but it ain't. The second issue is to whether fiduciary duties differ on whether you have a closely held corporation on the one hand or a Coca-Cola on the other. And the third is what you do when the actions by the officers and directors were really sloppy, classic breaches of the duty of care. But they may have been affected by other things like intervening cause or no cause at all. Let me talk about these very quickly. I can talk about this stuff for hours, and I'm going to try to do it in another 5 minutes or less. First, a lot of courts have held, including me when I repeated stuff that other courts ahead of me had held, that when a company goes into insolvency, fiduciary duties change and they run in favor of the creditors. Well, the most recent thinking on that originally comes out of Delaware, in which I followed to apply it to cases under New York law, corporations organized under New York law as well, is that fiduciary duties always run to the corporation itself. They don't run to shareholders, they don't run to creditors. And the only thing that insolvency does is it changes the types of people who can bring derivative suits on behalf of the company. But that really doesn't affect anything that we see in the bankruptcy community at all, because if you're talking about a claim that's owned by the company, it's owned by the debtor in possession if you still have one, or it's owned by a trustee if you, on behalf of the estate if you don't, and if, by way of example, you deputize a creditors committee or a litigation trust to bring those claims, they belong to the litigation trust. What that means as a practical matter is that the solvency of the company doesn't make a difference. Because if management owed the duties to its corporation, it owed that duty of care, irrespective of whether it was solvent or not. Because the duties were already owned by the company in either case. And that's what I held in Perry Copley. I should say that that was a non-core matter, and the findings are subject to the review of the district court because they're only recommendations to the district court. This was obvious even before Stern versus Marshall, so stay tuned. The second issue is, do duties for closely held corporations differ? And at least under New York and Delaware law, I decided that under New York law by analogy to Delaware law, since New York law was thin on the subject. Officers and directors of closely held corporations have fiduciary duties as well. We cut them some slack on corporate formalities. You don't need me to tell you that closely held corporations don't always keep the best minutes or have the meetings that they have. But ultimately, those same principles apply. The third principle is that we still have to pay attention to causation. Now, in the Perry Copley case, the officers lent something like $6 or $7 million to a company without bothering to get any promissory notes. But in fact, the issue turned on not whether the debt could be proven, but whether the company they lent the money to could pay the money back. So the failure to issue the promissory notes didn't cause the loss. They also lent $7 million without looking at the borrower's financial statements. But it turned out that the financial statements were fraudulent, and even if they had looked at the financial statements, it wouldn't have done them any good, because it would have looked like they were lending them to a company that could afford to pay them back. So you can go on this way, but I would encourage you all to look at causation along with the underlying breaches of duty, to see whether whatever the officers and directors did that was bad actually caused the debtor's loss. And with that, Trish, let me pass on to our next topic. And, you know, if we have time, we can come back to this unless you have a question.
No, I don't. I just, I think the takeaway is that, some closely held companies whose books and records are sloppy it may still be okay if the sloppiness doesn't cause the loss and you don't have causation.
Yes, exactly. What you really have to look at, although this is all fact-driven, is with whatever level of formality or lack of formality they used, did they use appropriate care under the circumstances? And the answer, I guess, is going to be sometimes yes and sometimes no.
Okay, so our last topic that we're going to talk about is involuntary proceedings. And Judge Hopkins, what I didn't tell you when I introduced him is one of the other things he's done over the last couple of years is sit by designation and visit in the Middle District of Florida in the Fort Myers Division. And in Florida, those of you who have looked at our case law know that the cases are very strange, sometimes really odd in terms of rulings and people's behavior. And so we're the Ponzi fraud capital of the world, and we're actually proud of it.
Gotta be known for something.
And so involuntary proceedings have been the subject of a lot of abuse, I know, around the country, but also in the Southern District of Florida. We have some pending now that have been pending for almost 2 years for a determination as to whether or not an order for relief is going to be entered or not. We have issues with respect to who the alleged debtor is, where there are various people claiming to be the debtor, and the court has to make that determination. Those issues also will have stern applications because they're going to the 11th Circuit, and the issue will be whether the court could decide in the context of an involuntary in determining who the appropriate alleged debtor was, issues of ownership that arise under state law. So stay tuned for that. But Judge Hopkins, you have an issue in an involuntary with respect to the bad faith conversion of an involuntary, and I think it arose in Fort Myers, correct?
It did. And the lawyer who was a participant in that is here today. So he should probably come on up and join me. It arose in an involuntary case. It was a case that was in a receivership. It's the Naples Bay Resort down in Naples. Beautiful place with lots of amenities, most of which I can't afford, so it's living in a it was nice to see it. But it was in receivership, and they were fighting in state court for many years, approximately 2 years, I believe, over one of the owners of the resort having bought secured debt and was attempting to foreclose against the resort and regain ownership and control of the facility. An involuntary was then brought by certain of the creditors who were in part of the other ownership group in the bankruptcy court, which was a little odd. They wanted to keep the receiver in place, keep the receiver operating. The receiver had hired a management company to operate the facility. So we were challenged with whether or not an order of relief should be granted in the first instance. If you look at the rules, they say you're supposed to try and adjudicate that matter as expeditiously as possible, so that obviously the debtor is not hanging out there and perhaps losing business and losing business opportunity. So the question that came up a little bit later down the line, we really never got to the order of relief over about a year's time. Interestingly enough, the issue that came up later on, I followed one of Bob's colleagues in New York, Stu Bernstein, had a decision called Euro-American Hotel involving whether or not you could convert an involuntary case into a Chapter 11, and whether or not you could do it over the allegation that the conversion was being made in bad faith. And to my surprise, frankly, I was very surprised, the courts have applied the Marama decision that we talked about earlier, Chapter 13 case involving a debtor who sought to convert from Chapter 7 to Chapter 13 when, lo and behold, assets were found that he had not listed in his schedule, and so instead of having the trustee liquidate them in 7, he wanted to retain them and keep them in 13 and reorganize. And the Supreme Court in that case essentially said that is not bad faith. That is, but interestingly enough, the Supreme Court grafted, in my view, onto the conversion statute 706 this whole question of good faith, bad faith, because if you look at 706, it looks like a straight conversion upon the election of a debtor to convert from one chapter to another if they're not disqualified from having filed in that for any reason. they can convert. But the Supreme Court, in an opinion authored by the Chief Justice, has said essentially that if you are deemed to not be a good faith debtor in that particular chapter, you can't convert. And so taking that statutory analysis, or at least that doctrine, courts have now applied, as do in the Euro-American case, applied the good faith conversion doctrine in the context of involuntary Chapter 7, seeking to convert into a voluntary Chapter 11 where the debtor can reorganize.
So what do you end up litigating in that good faith motion then? Whether it's sort of essentially whether or not it's better to just to do nothing or to convert and appoint a trustee or abstain or excuse turnover by the receiver?
Right. You know, what it boiled down to was really intense facts examination as to whether or not the debtor was serious about attempting to reorganize. And it seemed to me, after I heard all of the evidence in the case, that conversion and the appointment of a Chapter 11 trustee was the appropriate thing to do, because the parties were going to continue to litigate every aspect of the case at every turn. You would not believe how I felt like you, Bob. I did pleadings at 8 and midnight, and the next morning, a minute before the hearing was being held, because rather than having them litigate their way to perhaps a successful reorganization, seemed to me the better thing to do was to appoint a neutral trustee to come in to run the business and let the chips fall where they may. Because it was an operating business, obviously, it was a very plush resort that was brand new in Naples and the shiniest point on the beach.
Yeah, Judge Williamson in the Middle District of Florida has also declined to agree to convert a case from Chapter 7 to Chapter 11. In this case, the involuntary petition resulted in an order for relief, and then the debtor came into court asking to convert, and the judge denied that. I'm similarly finding that, you know, a trustee was the better alternative in that case, and a trustee had already been in place.
You rely on the problem?
What
you mentioned?
No.
Too bad. Okay.
What was it? Did it have a reorganization feel to it?
No,
Yeah,
it did not have a
that was the
reorganization
difference.
feel to it.
Right. This case clearly was going to reorganize. It had the resources, it had the funds, it had post-petition financing, all the things that you need. It was simply unable to service its debt.
Okay, we've got about 5 minutes left, and if anyone has any questions, we have a brain trust up here who knows what's current, what's happening, and maybe can prognosticate as to what will happen.
Everybody wants to go home.
Questions?
Robin, you've got no
Last
questions.
comments from any of you?
Trish, I see no question, so I want to use, oh wait, there is a question. All right.
Just to go back to something that both Judge Gerber and Judge Hopkins mentioned about new cause, expansion of cause under the Red Lines decision. I represent a lot of people who buy companies out of bankruptcy will do very small loans, acquiring the debt, and things like that. And in general, I think when we look at what the risk is of not being able to credit, look at whether there's a problem with the invalidity of the lien or bona fide dispute about the lien to service all of the cost category. Presumably, at the law category, presumably, after the sum, but you can make out a claim for that. Just being a competitor and buying a debt as part of a process required of the company never would have occurred to me as a basis to not go out and credit. That's something that you mentioned. And so I just would like a little bit more color. What do you give?
Well, I think it had been mentioned as a possibility, but I don't think either one of us said that we would necessarily do that. And I think basically we said we anticipate people might argue it, and we'll keep an open mind on it. Historically, the bases for taking away the right to credit bid have been very, very narrow. And I think it's fair to say, unless Jeff would differ with me on this, that the presumption has got to be that that right to credit bid remains. You had mentioned if there's an uncertainty as to whether you're secured at all. That's almost like common sense. If you have a lien on part of the collateral, but not all of it. Excuse me, a lien on part of the property that's being sold, but not all of it. That might be caused under certain circumstances, but again, I would want to keep an open mind on it. And if it really, after you've shown by evidence that it chills bidding, that might be it. The issue you're having, you identified as one, Mr. Which I'm not sure that there's much of any case law on yet. But I think if you do have to consider an argument in that character, but you also got to look at it in light of the presumption that the right to credit bid remains. Jeff, I don't know if you would agree or disagree.
Oh, I cite the great philosopher Gordon Gee. Greed is good. I just don't see this being an issue. If you're, obviously, like Bob would keep an open mind about that, but it seems to me that that's the free market at work. When you're out there buying a debt and you're intending to use that debt to own, I just don't see that being something that's prohibited by the Bankruptcy Code.
Okay, anything else?
Well, how far does that deviate from your ruling in DBSD?
In DBSD, it didn't involve the right to credit bid. It was whether a creditor could vote on a plan where the debtor was going to reorganize as a standalone entity. And the claims had been bought up in par, and there was not in any way, shape, or form the usual desire of creditors to get paid back or to get paid back a larger amount of the claim. And as you might recall, Robin, each of the district court and the circuit affirmed me on that exact issue.
If it was that circumstance, they wanted to buy it up.
Yeah, they did. And we're talking 363K here as contrasted to grounds for designation of a claim for voting purposes. So I take it that you're not entirely happy with that rule, and I know 3 circuit judges up in Foley Square who you can raise that issue with. We have a constant issue as to whether we bankruptcy judges run cases to help our creditors get paid back or to help the distressed investing community. And that's an issue that's beyond the scope of today's panel.
And I think that one of the things is we're just trying to, the judges are looking at what criteria you might use for a cause under 363K, and some of the criteria that just seem to be naturals are the ones for designating votes under 1126C, and I think that's how the connect comes up. But with that, we're out of time, and I want to thank you for your participation. Thank you.